number 240-00057 as People of the State of Michigan versus Anaya Davis.
Robert Shockley, behalf of the people.
John J. Kennedy, P51549, representing Anaya Davis.
Okay, and what's your name? All right, and we're here with Davis again for pre-trial on this one count of assault and battery. When we were here last January 30th, we had some discovery, but you needed to review it with your client.
Yes, Your Honor. I'm making a motion to withdraw today, Your Honor.
What happened?
I'm unable to contact my client. I was told by one of her friends at the courtroom who indicated she was her attorney in fact.
She's not an attorney in fact.
Well,
she's not a friend in fact. I gave him an email discussing discovery. However, here tonight, in that discovery, I have a paper.
So you don't want him as your lawyer?
It's a breakdown to the case to us, and I answer the question and I ask. So yes, we're going to literally
we'll withdraw you.
And I will send
lawyer?
I will send her an email with the discovery. I was given an email today. And I'll let the MIDC know.
I'll prepare an order, Mr. Kennedy, if you want to wait for it.
Yes, Your
Honor. Your Honor, before we close the record in this matter, will you just inquire with the defendant?
I will get to that. I haven't gotten to that.
Sorry, Your Honor.
Okay, so here's the order releasing Mr. Kennedy as counsel for the defendant, and he'll get your discovery over to you. So how would you proceed? He said you say you have a lawyer with you. Okay, who's your lawyer?
This photo. Piece of case.
He's withdrawn, and you can't disclose it because I asked you. So who is it that you're talking?
I'll email the card.
You what?
I'll email the information. I'll email the card.
So who?
Court experiences by my attorney that's been taken over.
Who you are?
The court, you're inquiring, I cannot give it to you.
Well, how okay, man, let me tell you something. This is how it works. You respond to information the court's asking for. If you can't do that, you are technically in contempt of court. You don't want to sit in jail because you don't respond to the court. So sounds like that. And this is a simple question. I'm the docket right here, and I need to know who you're talking to so that I can verify whether or not you're even have a lawyer or not. Otherwise, if you don't have a lawyer or not, you're just going to be representing yourself. Because I'm not assigning you a court attorney, right? Because you're telling me you don't. And a simple question, the answer is who your lawyer is, or who you're even talking to. Okay, well that's fine. So I'll make it go.
Yeah.
How would you like to proceed then? Would you like to, is there any offers in this matter? Even this, I'm giving you a copy of the order. Is there any offers? I heard of that.
No, that's not Your Honor.
Okay, well, like I said, try.
No. How I work in this with jurisdiction. And to the fact that I have not been able to, in the game of discovery, I don't even know what I'm getting.
Okay, if I can reach that part. Now, I can't get to this, ma'am. You don't have a right to say anything. I don't know who you are, but you're not a licensed attorney. So if you could please please have a seat. You don't want to get arrested either. I'm not going to tolerate this. No, you're not doing anything but sitting down. That's what you're doing. Now, I can tell you what the charge is, but I can't give you this because I don't have it. So the prosecutor has a copy, but you're entitled to get to represent the subject, to get your police report, any videos or anything else they may have. Your lawyer, your ex-lawyer said that he will send you that by email. So if you don't get that, you can feel free to contact this lawyer here, who's your prosecutor, and he can resend it to you. Okay, ma'am. What happens is they send it to your lawyer. They don't send it to you because you're represented. And he cannot legally have contact with you when you have a lawyer. So he would never send that to you. He would send it to the lawyer. Now, your lawyer, before he left, indicated that he was having some kind of problems contacting you. You even said you were having some problems communicating with him. I don't know what that was about, but I did release him because you both said you wanted to go your separate ways. So I don't know why you didn't get it from him, other than what he said generally briefly was that he had not been able to contact you. So he says he will email you this now and we'll make sure you get it. He will not do anything in this case without you having what you properly need to defend yourself. Nobody's trying to do that, but you certainly have those rights. We'll make sure you have that. So he's saying right now, based upon his review of the information, because it's in the prosecutor's discretion, whether or not the case even gets charged or not, and whether or not they voluntarily dismiss it. See, I can't do that. That's not murder. But my job is I can't just dismiss the case just generally, even if I wanted to, I can't. I only can do that if I have a trial, I'm the evidence, or things of that nature, and I can make a determination that he's not carrying his burden of proof. He, being the prosecutor in his office, are the only ones that can just say, okay, I want to dismiss the case. And sometimes when you have counsel, depending on what your police report says and that other information, they can begin negotiations with the prosecutor's office to reduce charges, dismiss charges, things of that nature. None of that apparently has happened because you and your lawyer hadn't even been able to talk about it yet. So what I'm going to do is I'm going to adjourn this pretrial. We're going to make sure you get your discovery. Then at that time, since you don't have a lawyer, you say you're going to free to talk to the prosecutor. He just gave you his card. Once you review your police report and see what it is, and I'm going to read you what they claim the charge is generally. So once you read the police report with the specific facts that are in there, you'll get a better understanding of what they're claiming occurred. And then you could call the prosecutor and work something out, see if they'll dismiss it or any other number of things that could go on. So, but I'm going to read you what the complaint says, just so you know generally. It's like I have a lot of specifics in it. But the complaint says that on January the 13th of 2024, in the city of Fountain, he made an assault or assault battery upon a Lachelle Jones.
Yeah.
What you may have allegedly done, that's in the police report. That's what the claim is. So we need a new date for her to come back.
February 29th at 1:30.
All right. February 29th, 2024 at 1:30 is for a new pretrial. Thank you. We'll get a note that she's to receive her discovery, review it, and possibly speak to the press. If you do get a lawyer between now and then, the lawyer should be here on the 29th with the discovery and ready to talk about this. So your bond is going to be continued. That concludes that.
This is case number 240-00057 This is people of the state of Michigan versus Anaya Davis Sealy. And are you there, ma'am? Hello? Yeah. And tell us your name. Anaya Davis Sealy. Okay. And so today is the adjourned date for the pre-trial. We adjourned it for Ms. Davis Sealy to receive discovery materials and review whatever the information was, to talk to the prosecutor and decide how she would like to proceed. So did you receive your discovery, Ms. Davis Sealy? No. Okay. You didn't get it from your former lawyer? No. You
just as a record, but the last 7 months was up, I handed Vasily my card, no contact ever been made by her.
Well, Ms. Sealy, he indicates that he gave you his card to contact him so he could know where to send you your discovery. But you didn't contact him, so I guess you didn't get the discovery. So what would you like to do today as far as, setting it? I can go over email. You did what over email?
I could give an email.
Oh, okay. She says she wants to give you her email.
Go ahead.
At yahoo.com.
I said we couldn't hear the yahoo.com. We could not hear the first part. At yahoo.com. Got it. Got it.
And what's the email it's coming from?
What? It's going to help from OCPO Discovery, OCPO Discovery at oakgov.com.
Okay. How quickly does that get to her? What, and so you're sending it like today?
Yeah, when there's something about the OCPO Discovery, you send it the same day.
Okay, so he said that he's going to send an email to the Discovery people and they will get it out to you the same day. So if he does that, I guess now, you should probably get it later today or worst case by tomorrow.
Okay.
Okay, so he's got to get that over to you. Would you like to set your case for trial or you're not sure yet? You want another short adjournment for a pretrial?
So I have to review the discovery.
We'll give you an adjournment for a pretrial to review discovery.
What's available March 13th at 10 a.m.
March the 13th at 10 o'clock. And that will be in person. And if that your bond is continued, then we'll see you there then. Okay?
Okay.
All right, you're all set for today. Bye-bye.
Case number 240-00057 SM, State of Michigan versus Anaya Davis.
was shot on behalf of the people, does not appear to see.
And defendant has failed to appear, and so is defense counsel. And it's now 12 noon.
Judge, remember Mr. Kennedy was released.
Oh, yeah. So Mr. Kennedy was released. Defendant has not appeared. So a warrant for her arrest will be issued. Any bond posted is forfeited. Giving me a copy of the Constitution of the United States.
She gave you that?
Highlighted, underlined, and all kind.
Must be jurisdictional.
And an affidavit of truth to cease and desist and a warrant, writ of quo warranto redress of grievance.
She
But we don't have her,
mailed that in?
or dropped it off on February 26th, but she's not present. So, the bond previously set was $250 cash or surety. And this is an assault and battery now. It's gonna be at $850.
Okay, pause. This is the moment everything in this hearing flips. The judge is giving a direct warning about contempt, which is basically the courtroom version of you're about to get arrested if you keep playing games. And look how calm, but firm, she is. What would you do if a judge told you this? Speak up, freeze, or lawyer up? Let me know in the comments.